Okay. Michaela, would you mind just getting the door in case? I hope it's not too hot for everybody in here. Oh, no sponsored advertising. Any questions? A lot of you have been corresponding around papers, and that is good. Any questions on any of the logistics of the course and any of the really important stuff? Okay. Office hours remain 2:30 to 3:30 in 427 if anybody wants to drop by. I expect to be there today. So today, as I'll explain, be talking about largely privacy and a little bit about regulation and a small, shallow dive into constitutional law, but mostly privacy. And that is not the most natural subject for those of you who are gamers. It just doesn't come top of mind. So it's been an interesting piece to put together. But first, following up on last week quickly, really nice piece that came out a day after last week's class called Video Games and Societal Violence, Cause for Urgent Action or a Bridge Too Far, where far better stated than I did, found that a number of the suggestions that we discussed in last week's class showed up in the Huffington Post. More interestingly, have posted on the blog, and hopefully you've seen this, if not on the blog, then somewhere else, Donkey Kong Pauline Edition, which is a lovely, wonderful piece. A father was asked by his 3-year-old daughter if she could play as the princess and save Mario instead of the other way around. And he hacked Donkey Kong to achieve that, and the gameplay video is on the web. Also, there's an article very apropos to the discussion last week and the discussion in the media and entertainment law class last week on video games, that is frustrating. And the article's called "You Can't Have a Female Character in Games." And what it really is a reportage on industry figures who say you can't have a female character in games and how ridiculous that is. My colleague at the Center for Digital Media, Kimberly Voll, has decided to do something about that. And those of you who know what a game jam is, it's everybody getting together for a short period of time, foregoing sleep and creating a number of games. Kimberly is going to do a game jam this summer at our facilities at the center with a theme of games with strong female leads. So action better than just reading and criticizing. So this week, privacy. Really didn't feel like a very natural topic, and was trying to figure out why. And it became really obvious. If you're a gamer, for the most part, for a very, very long time, now, you guys are a lot younger than I am, but it was single player. And you were was you and your computer or you and your console, and there was no connectivity or precious little connectivity. And to the extent there was community, it was online forums around the game. So there might, that might be where you would feel some issues around privacy, but certainly not for the longest time in actually playing the game. So as games moved from hard drive to online to massively multiplayer online, and now to the cloud, these issues start looming large. But even in past lives in 2005, writing about this stuff, privacy felt like a big issue to come. And even more recently, when Rock and I were working on it, yes, the issues were starting to become real. You had the hacks on Sony and the PlayStation, and all of the data, if you were a PS4 online subscriber, becoming or being available or being hacked. But the form of all of this wasn't even that clear 2 years ago. And it's in the last 2 years that we're really starting to see some shape as to what privacy means and what the different layers of privacy are. Now, one small deviation. I just want to talk about community in a slightly different sense. This week, some research was released in which it was discovered that online communities through Twitter have their own languages and have their own reference points. Which, if you're a gamer, perhaps makes you laugh. Because this isn't news. Gaming communities and gaming communities online have always had communities of interest and specific language around the games they love, and have been very connected to their communities of their games, and very often of their game. So for me, for many years, it was a game called Grand Prix Legends, and I reveled in the idiosyncratic obsessions of my fellow gamers and community who would do something like, if you're looking for a link, there would be a 50-page thread on the details of what a particular racetrack should look like and mods to that racetrack to make it look exactly like it did in 1967 when the game was set. And there were debates as to whether a particular billboard should literally be 5 feet over from where it was placed in the game. So community and the languages of community are, in fact, nothing new. Now, to try and situate us a little bit, let's talk about privacy in terms of other things, other reference points that we've had in the course. And the obvious one is IP and copyright. And social consequences. So let's start with what we talked about last week. Last week we were talking about violence, we were talking about sexism, and in essence we were talking about the rights of society from the consequences of what gamers, and occasionally, in the case of hot coffee, modders, and sometimes game companies do. This week, we're really looking at gamers as members of society. We're looking at us in terms of what protections do we want, do we need, in terms of our privacy. All of which is made more complex by exactly the same thing that makes intellectual property in this course complex, and that is that gamers initiate content, don't just passively receive it. And if you think about the act of playing a game, video or otherwise, there's an enormous amount of information and data about yourself that becomes available. And if you've ever played competitive sports, you'll know you learn an awful lot about the other people you play with just by playing with them. So what we looked at in terms of intellectual property complexity now becomes privacy complexities. So one more small piece of situational analysis. You'll remember the layers of control slide from the last couple of classes. This is just my version of where we're going to be focused today. Some aspects of privacy appear under industry self-regulation, but I kind of put it in purple because important, but it's not where you're going to see most of the stresses. And most of the stresses around privacy are out of the game. They're normative, and usually, almost always, have some degree of government involvement. Regulation, consumer protection legislation, and even aspects of antitrust competition law. Now, the other final, I'm not just regurgitating my old slides. And you'll see just to prove that, I add the occasional new piece in here. But as promised, want to stay with our hypothetical, which is that we're moving the game into the real world. And the Connect being one part of that, and now we're seeing ingress, and we're seeing all of these tools become available. So as we analyze privacy, please try and stay with this model. Did find, and this is not in the legal academic world, but in the gaming academic world, a really interesting article called "The Plays and Arts of Surveillance, Studying Surveillance as Entertainment." Surveillance is fun, is the notion, and it certainly can be. But we're going to come back around to what surveillance can mean in some less fun contexts and how all of that relates to privacy very shortly. So let's talk about think about the sports analogy, but also think about gaming. Let's talk about your digital footprint for a second. Because when we talk about privacy, yes, you're playing, yes, you're initiating, yes, you're interacting, all of those things that we know through other aspects of the course. But now, what does your device know about you? And this is by no means a definitive list, so would love to hear other ideas, other suggestions. And this area of feedback mechanisms, if I can call them that, is expanding constantly. And of course, all the data, at least in theory, is either collected or collectible, can go into the cloud, and by that hangs a lot of the conundrums we're going to talk about. So, big one recently, facial recognition. And you're already, if you're on Facebook, you're pretty well profiled. And they have extremely sophisticated software. And you, if you're on Facebook, get notices asking for confirmation that this is you. And this is happening in an automated way, not just because someone has tagged you. So facial recognition being incorporated into devices is happening, and clearly it's happening with gaming. And I don't know what the next generation Kinect will be able to do, but my current generation Kinect has got a pretty good idea that it's me. And exactly how it has that idea, exactly how it has that profile, and what is done with that, I don't really know, not having read the end user license agreement. The other obviously big issue is cell tracking, geolocation. If you're on Foursquare, you know all about that. Ton of demographic data about you because you've told everybody at various times to access various features or various services a fair bit about yourself. Andrew.
I remember reading a pretty compelling argument that Google ventured into the mobile phone market, not so much for a lucrative mobile phone market, but really because it would accentuate the level of information that they had, because they already have so much information about what you're searching, what you're looking for, but matching that up to who's doing it, where they're doing it, and when they're doing it was just a huge next step for them.
Right, and I would say in a gaming context, and we've talked about a little bit, but Ingress, which basically turns all of us into mappers of the world for Google, might. I'm sure it's motivated by fun. I'm sure it's motivated to be a great game, but it also does a whole bunch of fascinating data collection things. And because Google is so cloud-based, again, all of that gets merged somehow. And you'll have noticed that Microsoft's latest campaign, which seems to be aimed at Google, which is called Scroogled, is about letting people know that maybe they should have read their Google end user license agreement more carefully, and that they don't really fully understand what's being done with their data.
You said to look at where the companies make their money. Google's an advertising company.
Yeah.
And that's
it.
Yeah, they get their money from information about you they can use to advertise.
Just don't tell that to their development teams.
Yeah.
A great advertising company.
And one, just from a past life, I'll make the observation in relation to that broadcasters were desperate, and I was of that group. We were desperate for information from the cable companies about the people who were watching our channel. We had, broad ideas of ratings, but we didn't have addresses. And of course, in Canada, 95% or 98%, probably up to 99 at this point, get their television not over the air, but through a cable provider or a satellite provider or a phone company. And of course, they jealously guarded that information. They would never, cable company would never give a broadcaster any of that information, because the cable company regarded you as their customer, and the content provider regarded you as our customer. But at the end of the day, cable was in the middle, and they wouldn't give us that information. What's happening today is that companies, by being vertically integrated in the new digital space, are all one. It is the broadcaster and the cable company as one. And of course, we're seeing that vertical integration in the traditional media space as well. So it's, don't want to pretend it's not now happening. There's we've obviously because there's information about your demographic data. There's also information about your friends' demographic data and those relationships. Increasingly, we're seeing games based on. Now I'm getting a little science fiction-y on you, but we are seeing games that can be controlled through your brainwaves. There's a Kickstarter that I mentioned in a previous class on that, and I think we'll see more and more of that sort of gaming. Well, there's obviously a lot of data in your brainwaves, and if somebody's measuring that, that's pretty intrusive and pretty interesting. I don't know what that data means. I'm not a psychologist, only related to psychologists. But you could couple that with all the reflex and physical data that you could gather through controllers. And here's the one that nobody talks about. And here's where I think the most interesting possibilities, especially, as Rock said, if Google and others see themselves as advertising companies, is think of yourself as a gamer. Think of the choices that you make. Think about the decisions that you make. Think about the patterns of how you make choices and decisions all the time when you're playing games. Think about all that data being collected and a psychological profile, not just a data profile of how old you are and what your likes are and who your friends are, but somehow all of this material being merged so that there's a pretty, right or wrong, a pretty detailed psychological profile of you and how you make decisions.
Did we see a study? I didn't see the study. I saw the news report talking about the study. I didn't see the study. About how they can predict aspects of your personality just based on what you like on Facebook. Something about how, even your sexual orientation, something about how if you like Desperate Housewives, you were, I'm serious, this is a quote from the article.
I had a friend at the University of Waterloo. He was doing his master's, and him and a friend were actually developing this as a business. This is probably 2006, so Facebook would have been very early days. They developed a thing that could crawl through people's blogs and tell you, based on what the person was talking about, what they were liking. They could tell you a huge range of demographic information just based on what somebody was posting and talking about, like, I like this pair of jeans or whatever. They could tell you, geographically where they were. They could tell you the approximate age. They could tell you the gender. They could tell you so much information. And this is, that's almost 10 years ago. The technology and the search algorithms have well gone past that.
1 and 2.
I remember a year or so ago, or a little more than that, Target was able to track their consumers to such a level that they knew if someone was pregnant before they did. I remember reading a story about that. Maybe that was an exaggeration of an example, but they knew so well what people were buying. they knew everything about their lives based on that.
Well, and that gives you enormous predictive capabilities. So I'll give you my crazy example in a minute that I've been thinking about, but Ken.
Well, one of the aspects is the development of biometrics for ID and for security purposes.
Yes.
And then as you add that into the possibilities of data mining by cross-referencing a variety of databases, it has all sorts of consequences for the possibility of anonymity or anything from being able to tell how you voted or any of those other sorts of things that are supposedly protected. If you can put together enough database from the selection of things that people have chosen, from the information about them personally, the whole possibility of being able to then strip away any kind of protections of anonymity, the secrecy of the ballot box, any of those sorts of things are all gone. That's why privacy has become such a huge issue.
So let's as an example, imagine that I truly, deeply, and passionately hate the Dallas Cowboys.
Hypothetically.
Hypothetically. And Tony Romo especially. But let's not go there. And let's imagine that I had access, either because it's somewhere published on an NFL website or an NFL media guide or somewhere, to all of the NFL refs. And let's imagine that I had some really good hacker friends at the, let's say students at the Center for Digital Media, and they were able to figure out where all the refs were. And let's say I had some of the same algorithmic push technologies that Google and Facebook have that can place ads and place news items tailored to you. And let's say we could figure out how to tailor not even false stories. We're basically going to curate every bad story we can find from anywhere, whether it has to do with football or not, about Dallas and about Texas, and we're going to figure out how to push it to those referees. And we're going to do that for 3 weeks before the big game. I don't know how possible that scenario is, but we can't be that far off from that scenario being possible. I'm pretty sure it's illegal because there's going to be a hack there somewhere. But it seems like from the things you've all said and from my kind of limited research over the last 24 hours that we're, 72 hours, but that we're getting to this place. So, a couple of, I'm sorry. I just, the one piece of confirmatory information, very similar to what a number of you have said. Just an article here, Netflix used subscriber data to make House of Cards a hit. So Netflix, of course, commissioned House of Cards, and in doing that, they used their own big data to help it along. Nothing wrong with that. Or is there?
Well,
Yeah.
what do you mean help make it a hit? Like how did they use the data?
Well, they use the data to push. First of all, they use the data to know who their audience is, to know what they're going to commission, and then they use their data to push to you information, as much information as possible about the series. And none of that's illegitimate. It's just that you didn't sign on to Netflix so that you signed on to Netflix, generally speaking, thinking you would have a choice. And up until now, their content has never been an issue because they didn't have their own content. Now they do. And their advantage, and the story suggests they're advantaging it over other people's content. 1, 2, 3, 4.
I'm not saying I agree with this, but there is that other perspective that you as a consumer, it's helpful that they're targeting you with stuff that would be of interest to you as opposed to stuff that's randomly out there, helps you to sort through to the stuff that you would actually want.
And
I don't think I agree with it, but in theory, there is that argument as well.
well, the thing that surprises me a little bit, because I'm an old guy, is that in various classes at various times I've heard students say, no, the trade-off is fine. I don't really care that much about my privacy. I care more about the convenience of having this stuff and I don't mind being told. So these are decisions you have to make, and privacy might be significantly overblown in that context. Now, in a traditional context, to a 55-year-old guy, some of this stuff is pretty frightening.
Well, I'm old too.
Yeah, no, you're not. No, you're not.
That much. Because you have the choice to still decline it. You don't have to take it.
So, very quickly, two pieces of legal scholarship, and just here are a bunch of books that I tried to go through that are more communications, not legal, but security, privacy communications books. But on the pure legal front, What Privacy is For is a really solid pushback by Julie Cohen, because privacy has become a little bit of a dirty word for exactly the reasons we've discussed. And The Law of Friction by William McGivern. This is really interesting because it talks about how easy it is to share stuff and what's called frictionless sharing. And the basic proposition set out is it should not be easier in law to share an action online than to actually do it. Anyways, fascinating, long paper, link there. I missed some questions, so let's continue.
Well, I was just going to say that, I mean, my understanding of the entertainment industry is that they were always looking for what people would want and trying to design stories and things for that. So this just seems like a better data set to use because, you know, it's all in-house, it's all there for you. So I don't have any, you know.
And just to build on that, I mean, and to get back to the question of how Netflix used the data, I understand that they used a pretty granular level of data. I mean, it was down to, you know, what parts of TV shows made people pause for how long.
Yeah.
Where did they stop and turn around and leave, and then how did you design House of Cards so that you were missing these elements, or the elements were timed correctly, so this is when people wanted to break it, kind of thing.
And to put it in a different context, do I really object if my gaming experience is going to be made much better by somebody taking all the data of how we all game and parse it out and improve the gaming experience? I personally don't have an objection to that. Where it gets a little queasy for me is I'm not sure I signed up to Netflix and agreed to what they are doing. And that is the cloud over a lot of this stuff.
I'm an old guy too, even older than you. And I remember a book by John Kenneth Galbraith called The Affluent Society.
Yes.
Which was essentially a discussion of the advertising industry. The advertising industry has always been in a bit of a quandary because on one side they have to say, well, we can't really create demand that much because if they do, they're going to come under regulation. And if they admit that they can't affect demand that much, then how do you justify charging somebody $1 million for a 30-second spot in the Super Bowl? So there's always this sort of balancing act that they put through. But what Galbraith's book was to do, was to decide about questions of who's setting the agendas for what you want to buy or use in your consumer society. And if this is in fact being manipulated, so that they are getting you to, you can't live without a particular type of product, even though you may or may not, and they can do that because they have enough information about you psychologically in those profiles. It allows for tremendous abuse outside of supposedly somebody like the government that's supposed to be responsive to some sort of notion of the overall.
So when I first got into media, the bogeyman was subliminal advertising.
Exactly.
And the point of big data is actually it's not subliminal anymore. It's data. And it's not manipulative. It's the opposite of manipulative. It's factual, but it's very, very deep.
I don't see that the advertising industry is any different than there were reports recently in the food industry that they're hiring neuroscientists to manipulate food products so that at a basic level we like them more, and how they can get increased demand that way.
So let's assume now that we've established the problem, because I think we understand what the problem is. Where all of this privacy stuff is going to go in the next 10 minutes largely is around disclosure and specific issues. So the issue is not that this isn't being done, or that it can't be done, or even that it should be stopped. Privacy ends up essentially being about what you know, except for one major fly in the ointment, both in gaming and in the world generally. Very similar to last week. Children. The 32% of gamers that can't consent. So, very quick magical mystery tour, because I want us to get to our special guest. Another recycled slide, but with a purpose. Remember a couple of weeks ago when we did the future of technology, the holodeck talk. I did the virtual arena experience, which I'd actually recycled from a previous talk. I've just in red called out on that wish list of things issues that implicate privacy, questions and problems. There are going to be workarounds to some of them. Some of them, I don't know how you work around, but it's for you to look at home. Also, this is a new slide. Want to go through the layers. And this will take a minute. So as we discussed, the gamer creates the information. It's your information at that point. You then share information for what we've talked about in the course as the magic circle. For your gaming purposes. And as a gamer, it feels pretty natural to do that, and it actually feels just fine to do that. Maybe not to everybody, but certainly to me. I understand when I'm online in a racing game, if I want to play these people, there's information that's being shared about whether I'm on the track and where I'm on the track, about my driving style, about my voice, and in many ways about my very identity to them. Good with that. Then there's the audio layer, which is really part of, 2 and 3 are sort of the same. Just wanted to point out that through Ventrilo and other providers, there is the possibility of having a purely private audio layer by permission only. You will only talk to the people you want to talk to, and then there's kind of the general in-game layer. And then it starts getting further away from you, and that is the developer and publisher using your information per the EULA, the game network, social network, using the information by terms of service. And then it gets to what I feel is a murky place. And that's the ISP, somewhat murky. But then when we get to network carriers and mobile carriers, and what rights they have to my information, that's a pretty gray place. But if I'm playing an online game through a mobile device, how much of it gets where? And what have I consented to? And then there's another thing that happens, and that is whoever has information can aggregate it, not necessarily sell you out personally, but can aggregate the information and sells that to advertisers and sponsors.
I'm just wondering how much of, if you think about it as, if you walk onto a field and you see a whole bunch of trees with oranges on them, and you go and pick the oranges. Nobody owns the field. You pick the oranges, you do something with them, you sell the oranges. We're okay with that. How is that much different from, you've created a game, people have walked onto it, they've done stuff, they've created data. Now you've got to take that data and make it useful. So the data by itself isn't useful.
Well, it's going to come shortly, but the answer is around what's the expectation of the people that played the game, that are playing the game and going onto the field, and what have they agreed to. So we'll get there, but I just want to quickly get to the last two layers because they are important in the law of privacy generally. They'll feel a little remote from a gaming standpoint, and that is access by law enforcement to, so everything, this is maybe the key concept for today. You got to decide what you have a reasonable expectation of privacy towards, and I'll show you the statutory basis for that in a second. But you got to remember that everything that you say you're comfortable being out there with, that you don't necessarily think is private, that is public, and it's also public to law enforcement. It's public to anybody. They don't need a warrant for that stuff because you don't have a reasonable expectation of privacy around it. And that's the law, and that's what those 9 books are about. And then you get to the top layer, which is the search warrant layer. So the legal question is, where does your reasonable expectation of privacy begin? Where in all of these things do you expect privacy? Is it just 1 and 2? Just me and my magic circle? Or is it somewhere along the continuum? And then we've talked about it briefly, but I just, so you know I noted it. Is this even an issue? That's the practical question. And if you're interested in kind of the top layers down, absolutely awesome location tracking and biometrics conference at Yale, which is online. It's on the blog. Please read the blog, because the one thing I've done for you, they stuck the whole 9 hours on, including breaks. So that they didn't edit it. I've given you a guide to where the edit points are so you can sort of skip through and not just sit there through a lunch break. And I've given you kind of precise timing. But it's absolutely fascinating. And when you look at it through the lens, I mean, this is a very concerning issue to privacy experts generally, but when you look at it through the lens of gaming, and biometrics through the lens of gaming, it really becomes interesting, because a subject that feels a little distant became a lot closer for me anyways. And then a very interesting part of a thesis from Christopher Segoyan, who also spoke at that conference, if you want something in writing. So, Privacy Act BC, the key is the nature and degree of privacy to which a person is entitled in a situation or in relation to a matter is that which is reasonable in the circumstances, giving due regard to the lawful interests of others, unless there's consent or it's required by a peace officer. Whoop. Sorry? I gotta go backwards here.
Gar, the one thing I think you raised an interesting point when you talk about the oranges. I think I would characterize data and privacy as being different. I think your data inherently has value. You know, a plant sprouts from the earth, no one owns it. I guess technically the queen owns it. Really, no one owns it, you can have it. But your data comes from you, your interactions, who you are. I think that inherently has value. I think that's recognized in the industry. You know, I was on Microsoft's site yesterday looking at the Office cloud software, Office 365, and they are advertising as a key feature data portability. If you decide to leave, you can have all your data. The data is yours. You watched Marissa Mayer, the CEO of Yahoo, an interview she gave a couple of weeks ago. You know, she's trying to restart Yahoo, and she's saying, listen, the data is yours. You should be able to take that data and migrate it anywhere you want, cross-platform, and use it. I think it's a concept in law you see in other areas. If something comes from something else that has value, you know, the fruit has value as well. You talked about confidential information. If you misappropriate my information and develop something off it, you don't own what you made using my misappropriated information because it came from something that had value to me. And I think the same thing applies to your data.
Just want to show you something I discovered yesterday. I told you that just for the fun of it, I wanted to delve a little bit into Linux gaming. So I installed Ubuntu on an old computer, and I found something, and it may well be there in my Windows, or it may well be there in my Apple systems on my laptop, but I've never seen it as explicitly or as simply. And it's just, I'm sorry for the quality of the bad quality of the picture and how small it is. But this is actually my screen, and you'll see it says privacy. You might not see, but it says privacy at the top. And there's a fascinating little slider here at the bottom. I've never seen it anywhere else. And it simply says record activity, yes or no. And it just made me focus on the fact that everything that you do on your computer is generally, unless you've got record activity to off, and I don't know where that is on anything else, is recorded and is therefore accessible. I mean, we know this, but that was just such a graphic reminder, and seeing a screen I'd never seen before, that gave me legitimately a sense of real privacy, was fascinating. In any event, here's the search warrant provisions, and a couple of interesting pieces. Article by Michael Geist talking about how Canada's telecom companies are not always requiring search warrants. This is also very much an issue in the Yale conference that comes up a lot. But then our courts are going in a pretty progressive direction, depending on how you regard privacy. Jones and Sieg, I'm not sure if that's the right pronunciation, Ontario Court of Appeal recognizes new tort for invasion of privacy a couple of months ago, and the Supreme Court of Canada in the Cole case finding a reasonable expectation of privacy in a work laptop. So, what's your reasonable expectation of privacy around your gaming experience? And now take that out of your computer and being in front of it, and move that to your Xbox with Kinect. Do you have less of an expectation or the same? And now move it out into the world with Ingress and Google Glass. And what's your expectation of privacy there? And is it the same, or has it shifted?
It's one of the questions as well, is the whole notion of consent. You can, to escape the sort of provisions of the Privacy Act, if you can get consent. But one of the problems is if the information or the data that's being collected is being collected for a different purpose, the consent that you have in fact secured needs to be reconsented, and you have to go back to the people that you collected the data from and say, we'd like to use this data for a different thing. Are you still okay with that? If not, then the whole defensive consent is vitiated. And so that becomes a problem when you're talking about data mining and pulling a bunch of this information in elsewhere, is that in many cases, some of the algorithms, some of the sort of collections, the data mining that is being done, could not have been reasonably foreseen by members of the public or the gaming community. And so all of a sudden, if they're starting to pull out information about you that you wouldn't want to have released to the general public or to the medical insurance company that's going to refuse you coverage because you have a genetic predisposition to some sort of disease or problem down the road, then that's going to be a problem, and that's where a lot of this...
Well, let me make it simpler, because you're dead on, Ken, in my view. But let's talk about House of Cards again. Maybe they did, I don't remember, because as we know, and as I've disclosed many times, I don't read these things, and I know I should. I don't recall Netflix sending me anything saying, you know what, we're going to use your data to produce shows. Maybe they did. And that's something that, you know, will be an excellent investigation for next year's course. But that becomes the issue. Did they? Should they have? What did they get in the beginning? So now just to go to Zohar's point, you know, I previously alluded to the seeming conundrum between the IP literalists and the privacy literalists that seem to be on opposite ends of the political spectrum. And was there a core common denominator? And the core common denominator really goes to Zohar's point of the field. And that is, that's my information. What's the magic in it is that data is my data, or feels like it's my data. It feels like those ones and zeros are about me, just as it feels to the author or the creator that the ones and zeros in their creative work, and therefore the copyright and trademark and patent, is their property. So it's a feeling of property in both that is the common denominator, and I just wrote it out if anybody wants to read it through. Now, very quickly, some developments and final notes. In Europe, the right to be forgotten There's currently a case in front of the EU, but the notion is, and I've given you Article 17, and that it's especially relevant to data when someone was a child. So the children thing, the kid factor, comes up yet again. And it's a right to erasure. It's a right to remove stuff from your Facebook page because it's embarrassing or it's problematic. And there's a very sad article about Amanda Todd, if you want context. And as a father, I can say it's a very difficult thing to remind myself of. So the motivations are clear. On the other hand, how that gets dealt with, the mechanics of erasure, the mechanics of the process, seemingly are huge. Now, very quickly, one other common denominator in all of this. I know I've been picking on EULAs the whole course, so that's just one of the themes that's been emergent, but gonna pick on them one more time. And talked about previously, why are EULAs necessary given the 4 factors that we've discussed in 2 classes already? Need not remind you of that. But the positive answer of why EULAs may be necessary is leverage bad behavior and the IP stuff. Whether we agree with it or we don't agree with it, contracting out of IP freedoms. But now, those are more shield activities, protective activities. But around privacy, I think you'll find that EULA has become a sword. And one of the things you need to ask yourself is, am I contracting out of my privacy protections? What am I authorizing? And that's a little bit different. Feels a little bit different. Maybe if you're a modder, it actually would feel the same, because you would feel like your rights are being taken away if the EULA says you can't mod. But for most of the population, the EULA is simply about the company protecting itself. When it comes to privacy, it may be that the EULA is about aggregating rights of information, rights to your information. Just a very quick think piece, no way to do it justice, but if you're looking for a unified field theory, think about whether you could couch a right to privacy as a freedom of expression right, as a right to not express, a right to not have your thoughts, feelings, information, data, ones and zeros expressed on your behalf, or collected or used against your will. And you find a funny, if you think about it that way, you find an interesting common denominator. And that is that IP literalism and lack of privacy work together quite well. Because the reality is that if your information and data is out there about what you're doing, what you're creating, what mods you're making, and that isn't private information, all of that can be used to enforce intellectual property rights against you. So there's not a lot of discussion of this that I've found, but there is an argument that a lack of privacy chills user-created content and chills creativity. That's as far as can go. It would be a pretty interesting paper. But if you're an artist, if you're a musician, if you're online, think about that everything you've put online is out there. And if somebody doesn't like what you did or your riff sounds too much like theirs, you're vulnerable. And what does that do?
It reminds me of attribution, actually, because attribution has both sides, right? You have the right to be given attribution, but you also have the right to be anonymous. That doesn't mean that your data isn't going to be out there, though. So maybe there's something to be said for, the data is going to be there one way or another. It's going to be used one way or another, but attaching it to a person is still an option.
And to riff on that a little bit, moral rights may be a partial solution. Ooh, what horrible thing did I just do? Oh wait, somehow, how am I going to do this? How did that happen? Sorry.
I'm going to take this technical difficulty to disagree with John. So, I actually think that if you're, I guess for lack of a better term, an IP literalist, privacy is a tool you can use to protect yourself. I mean, I draft agreements where I group privacy and personality rights, which are very closely linked, with other forms of IP that the creator of the right or the owner of the right can license and enforce. So it's not as though that privacy is something that is not considered. I actually consider it one sort of abstracted as one of the other IP rights you can use and control as the content or data creator. And that's how I am.
And just to go back, this is a few slides ago. I skipped over it, but a moral rights model would suggest attribution and right of integrity. And again, moral rights, not to make it a panacea, can be a solution to some of these problems. So, to go to Zohar's point. Other issues quickly. There is an avatar versus real names issue. Facebook and others want your real names on the net. The history of gaming being about play has been about make-believe. And large parts of internet experience and the origins of the internet were around not your real identity. So that's changing, and have given you some good sources there, but the most interesting practice, of course, that's emerged over the last few months, or last couple of years really, is doxing. And that is an extra legal norm where you out someone. So if someone is acting badly, you figure out who they are, even though they have a hidden identity, and you out them for presumably the horrible jerk that they are, and people have lost their jobs that way, et cetera, et cetera. And we've seen a whole bunch of that in different ways around who the gun owners are after the tragedies in Newtown, and people outing gun owners and doing and the retribution that came from that. Series of lawsuits and actions and class actions against game companies and publishers around privacy breaches. The most amusing one being in the middle, which is action a class action against Valve and Steam, coupled with an amendment to the Steam end user license agreement that now prohibits class action lawsuits. And then finally, on the quasi-constitutional front, I just want you to have the sources, the new media exemption, which dates back to 1999 in Canada from the CRTC, where the CRTC occupies the field of regulating content on the internet, but then issues an exemption order and says, this is our territory, but we are not going to promulgate specific regulation. We're simply going to step back. The issue becomes, where is video gaming in all of that? And is it federal? Wanted to also give you a 1995 public notice from the CRTC where they did specifically regulate downloads of games from Sega through cable. So there's, strictly speaking, you have to decide whether they're asserting jurisdiction over the cable operator or over the video games. But it's generally supportive. And also you got to look at the Cap Cities case from the Supreme Court of Canada, which is where the Supreme Court of Canada asserted that cable regulation did belong federally, even though it wasn't, strictly speaking, broadcasting. And they used kind of a national purpose, not sort of a national purpose argument. And when you take those three together, it seems like a pretty strong case that if there was ever to be regulation of video gaming as a medium, it would be federal. And then the counter case, Bill 19, which was the 2001 Video Games Act, which got passed but never got promulgated. It actually got repealed. I've given you a link to the original statute. Is standard legislation basically saying mature and adult games are not saleable to minors, very much like the American legislation that keeps on failing in Brown and other cases in front of the US Supreme Court. And then you have to look at Irwin Toy, ads directed at children prohibited by the province as consumer protection legislation, and therein lies your provincial jurisdiction argument. And all of that really becomes relevant because the issue is kids. And here is the current state of play. The big issue that has penetrated the public mind is kids buying in-app, spending thousands of dollars in apps, and what have parents agreed to and not agreed to. Some good pieces that compare US and Canada. Generally, we're in the same ballpark. The SpongeBob piece is very interesting because there was no parental consent, and they were really asking kids for a fair bit of quite personal information. Sarah Grimes at U of T, who was a student in this course in 2001. She's now a professor at U of T. Her area of research is kids and games, and I should have given you a link to her stuff. I will do that. Next week, I really was just looking for an orc. I wasn't looking for an orc that looked like Schwarzenegger, but that's what I found in the Wikimedia files, which is what I feel safe using. We start to try and conciliate and bring all of this together, and we will talk about Brown, and we will talk about the Blizzard case, and we will try and start making sense of all of this massive information and bring it together in a nice little bow, because law should be that way in the next 2 weeks. No, it shouldn't. Thanks very much, and we are going to take the cameras down, and there are no cameras for the next presentation from